Coffee sent for the courts that the whites won't down to respect the rights of blacks, and that's why they lack the federal right to sue in this meant the jurisdiction is truly missing, cause the hue is different. The Brutus here to course cue the history in this opinion and rule the citizen truly isn't black like me, so the blues are given with this decision. This began in Missouri, yes, with a dude named Emerson, who originally owned the plaintiff and his whole family. The plaintiff was Dred Scott. By 1857 in America, no tensions were red hot over slavery, cause new states were being created. It was debated whether to make them slave states or to make them free. Now basically, Congress tabled this whole debate scene in 1820 when legislation deemed new states as free north of these coordinates, safe from Missouri. But the line was put 36 degrees and 30 minutes north. It was law until 1854, known as the Missouri Compromise, but a new law would undermine it. The rule was all but gutted by the Kansas-Nebraska Act. By the time that this fight reached the court of Justice Taney, who saw the rising tensions and felt that he must contain him. Some people felt maybe he got an improper hand from James Buchanan, the Pennsylvania president-elect, who tried to meddle with applying pressure to the court to end this whole debate over slavery. We'll get to the issues of this case. It's the infamous Dred Scott opinion. In America, no tensions were red hot over slavery, hot over slavery, red hot over slavery, red hot over slavery. Dred Scott. This is the decision of Dred Scott. And when it's climax, the opinion was written by Justice Taney. We'll get to the issues of this case, but the facts first before we proceed with this adverse ruling. See, Emerson brought Scott from Missouri to Illinois to Wisconsin territory and stayed there for a decade in total. In previous suits over freedom, for slaves to show that a free state was his home. For 6 months or more, then the case he had won. And bases was once free, then always. And based on that precedent, you think the Dred would win this one all day since both those territories were free. But this wouldn't be. He lost at the Missouri Supreme Court before claiming diversity of citizenship as a jurisdictional basis for this federal case. For instance, let me explain this. When the case pits citizens of different states against each other, this is what we mean by diversity. And here is established the Dred Scott van were purchased by a man named John Sanford, a New York resident. So this is why the question is relevant of whether Dred Scott is a resident of the state of Missouri counts as a citizen for federal purposes. But Taney's opinion said that he never did count as a citizen. But Dred just meant that his freedom was good to be when people didn't agree or they were heated by his reading. Next we'll see how he reached it. It's the infamous Dred Scott opinion. In America, no tensions were red hot over slavery, hot over slavery, red hot over slavery, red hot over slavery. Dred Scott. This is the decision of Dred Scott. Taney looked at the sentiment of the founders at the country's inception to show the descendants of Africans, whether they be slave or free, they weren't created equal in the lens of white supremacy. Interestingly, this didn't apply to native people. Maybe we'll touch on this later, but for now, this is how it went down. And stated simply, this Taney reason, even if a one-off stated deemed them as citizens. This wouldn't mean a thing, cause they weren't people. In the eyes of the founders, they weren't as sovereign either like Indians. They were just property. For Scott to mean trouble, he has no right to sue for the Constitution. And we're not through yet, Taney says, well, things are due, son. A rule, and if the right to own slaves is constitutionally protected, that's a right that Congress can mess with. No, they can't infringe it per the Fifth Amendment. But Taney said that's what they did with the aforementioned 3630 rule, which was Taney rule was unconstitutional. States get to choose their own rules, you know. Congress can't choose it for them, but it's what they did in the Missouri Compromise. This shit was wrong, allegedly. Go ahead and read Article 4 and Section 3 of the Constitution and take a look at just what Congress is do on the territory of the U.S. But Taney says screw that when he ruled that. And ruled that remove blacks from bond. It's like a compromise that just by crossing state lines like due process of the substantive type. In other words, he protected state rights while effectively stripping off black shit. His opinion was bad and written with the intent of just sending this one message that we simply don't matter. That's the basics. This crap is racist and backward. Basically, I have to say it's a legal abomination. It's the infamous Dred Scott opinion. In America, no tensions were red hot over slavery, hot over slavery, red hot over slavery, red hot over slavery. Dred Scott. This is the decision of Dred Scott.